Welcome to this explainer. Today, we are going to break down exactly how your company's financial standing gets evaluated in Malaysia. You know, your financial paperwork doesn't just sit collecting dust in a filing cabinet somewhere. It is actively scrutinized in two very different, very high-stakes arenas. First, by the regulators who set your compliance rules, and second, by the courts that handle fierce corporate disputes. Today, we're looking at both sides of that coin to understand how the rules of the game are shifting right now.
So let's just dive right into this by asking a question that I know countless Malaysian SME owners and directors agonize over every single year. Does every private company really need an auditor? It's a fantastic question, right? Because historically, the sheer burden of statutory audits has been a massive, expensive weight on the shoulders of small businesses.
To get to the bottom of that, here is our roadmap for this explainer. 1. The cost of compliance. 2. The new audit exemption. 3. The 3-year rollout. 4. Assessing your eligibility. 5. Your financial standing in court. And 6. The ABS solution precedent.
All right, kicking things off with Section 1, the cost of compliance.
For the longest time, the assumption was just that an audit was an absolute, non-negotiable necessity for corporate transparency. But honestly, at what cost? The Companies Commission of Malaysia, or SSM, recognized a really critical bottleneck here, and it was actually highlighted years ago by the World Bank. Basically, the demand for statutory audits in Malaysia was just insanely high compared to the actual number of qualified auditors available. It's like a massive traffic jam. And this imbalance created a costly, highly inefficient bottleneck, especially for small, low-risk companies who were just trying to operate.
Which brings us to Section 2, the new audit exemption.
To ease this immense financial burden on SMEs, while still, maintaining accountability, a major regulatory shift was introduced. The solution is Practice Directive 10/2024. This is a real game changer. This new directive totally replaces the older 2017 framework, and it kicks in for all financial years starting on or after January 1st, 2025. It's specifically designed to give a lot more companies, especially smaller SMEs, the opportunity to legally bypass that costly audit process, provided they meet certain size criteria.
Moving to Section 3, the 3-year phased rollout. So SSM didn't just open the floodgates all at once. To ensure a really smooth transition, they ruled this out in 3 distinct phases. Take a look at how these thresholds scale up. In Phase 1, which hits in 2025, the cap to qualify is 1 million ringgit in revenue, 1 million in assets, and a maximum of 10 employees. But watch this. By Phase 2 in 2026, that doubles to 2 million across the board and 20 employees. And by Phase 3 in 2027, it expands all the way up to 3 million ringgit and 30 employees. So what does this actually mean for you? Well, it means a company that doesn't quite qualify today might easily qualify by 2027.
Let's look at Section 4, assessing your eligibility.
Are you actually qualified right now? Because I'll be honest, it's not quite as simple as just looking at your current bank balance. To claim the exemption, you have to consistently meet at least 2 of the 3 threshold criteria we just talked about. But here is the massive catch. You have to meet these limits for the current financial year and the immediate past 2 financial years. For example, if you just incorporated your business in 2024, you can't claim this exemption in 2025 because you literally lack that 2-year historical data. Oh, and also, if you're a subsidiary of a public or foreign company, you're totally excluded. No exceptions.
And before we move on, I have to give you a quick warning. Even if the SSM grants you an audit exemption under PD 10/2024, you are not entirely out of the woods. Other bodies, like the Inland Revenue Board, LHDN, or your local bank, or specific licensing agencies, might still legally demand an audit for their own internal risk management. PD 10/2024 does not override the Income Tax Act. So you definitely need to evaluate your third-party obligations before you completely ditch your auditor.
Now for Section 5, financial standing in court.
Okay, now that we understand how you prove your financial standing to the regulator to get an exemption, let's pivot. Let's look at how your financial health is scrutinized in an entirely different arena, the courtroom. Because if you're utilizing things like audit exemptions, your financial paperwork might look a bit different. In civil litigation, under Section 530 of the Companies Act 2016, if a company sues you, you can try to demand something called security for costs. You're basically telling the judge, look, this plaintiff is financially unstable. If I win, they won't even be able to pay my legal fees, so make them lock up funds right now before this trial even proceeds. It's a really aggressive, strategic move to test the true financial reality of your opponent.
Which perfectly cues up Section 6, the ABS solution precedent.
This brings us to a frankly fascinating 2022 commercial high court dispute. ABS Solution against Limtech Ho and others. This case perfectly illustrates how courts evaluate claims that a company is broke. Here's the setup. The plaintiff, a Singaporean company, sued the defendants in Malaysia claiming they were scammed out of over 6.6 million ringgit. In response, the defendants attempted that classic blocking maneuver we just discussed. They applied for security for costs, demanding the plaintiff lock up 200,000 ringgit. Their whole argument? The plaintiff is a foreign entity, they have zero assets in Malaysia, and their sales revenue has no value. The plaintiff fought back hard, basically saying, "We just lost millions to you in a scam, demanding another 200K from us right now is a totally oppressive tactic."
So how did the defendants actually try to prove the plaintiff was broke? They relied almost entirely on a single piece of paper, literally. It was a corporate registry search from ACRA down in Singapore. On this printout, the little box for sales revenue simply had no value entered in it. It was completely blank. And the defendants pointed to this empty space and essentially said, "See, they have absolutely no money."
Well, the High Court Registrar, Ko Feng Ming, was not having any of it. The court wholly rejected this argument, ruling that a blank space on a foreign registry search absolutely does not automatically equal corporate insolvency. The judge pointed out the obvious. There could be a dozen administrative reasons why a specific data field is left blank. It just doesn't reflect the actual holistic financial standing of the company.
The court laid down some absolutely crucial takeaways here that really tie everything together. First, just being a foreign company without local assets isn't enough to trigger security for costs. Second, because Singapore and Malaysia have reciprocal agreements under an act known as REJA, judgments can be easily enforced across the border anyway, so the defendants weren't even really at risk. And third, and most importantly, the burden of proving actual financial inability rests entirely on the applicant. Whether you're dealing with unaudited accounts because of an exemption or foreign registry searches, an opponent can't just point to a blank box on a form and cry insolvency. They have to prove real, concrete financial danger.
As we wrap up this explainer, I really want to leave you with this final thought. Whether you're carefully calculating your eligibility for an audit exemption under PD 10 2024 to save your SME some serious cash, or you find yourself defending your company's standing against aggressive tactics in litigation like the ABS case, your financial documentation is your ultimate shield. So how well is your shield maintained right now? Thanks so much for joining me on this deep dive into the dual arenas of corporate finance, and I'll catch you in the next explainer.